A very good evening, everyone. Good evening to all. I welcome you. Okay. A very good evening, everyone. I welcome each one of you to my class on the Indian Penal Code 1860. Let's start with my brief introduction first. My name is Sandeep Khatri. These are my areas of specialization, as you can see on the screen. Here is the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. This is the link of my Telegram channel where you can connect with me, ask your questions, queries, whatever problems you are facing right now while doing your preparation. This is the channel where you can forward all your questions. At last, this is my code Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. I request everyone, please be attentive, and this is going to be interactive session. And by the term interactive session, I mean you have all the opportunities to ask questions. If you are facing any issues in this subject, you can ask your questions in the comments and I'll answer accordingly. Before starting this class, students, one important announcement that I have covered all these 9 special laws in my special law series in the special class. So if you are facing any issues in terms of explanation of these topics, or in case of if you want to go for important MCQs in relation to the subject, you can follow my series, that is special law series. Okay, and this is something which is available on in special classes, which means it's completely free of cost. Now, today we are going to discuss the concept of right of private defense. But before that, if you have any questions starting from section 76 till 95, which we have covered yesterday, you can raise your questions. Very good evening, Rashmita, and everyone, those of you who have just joined. If you have any questions, students, you may ask. Okay, so I'm starting with a new topic, students, that is right to private defense. When we say right to private defense, the very first thing that comes into my mind is the section numbers. Starting from section number 96 till 106 deals with the concept of right of private defense. Now, whether the term private defense has been defined, the answer is no. There is no specific section that defined the concept of private defense. But if someone wants to understand this concept of right of private defense, that needs to go through with all these 10 sections. Now, 96 to 106, which is 10 sections basically. These 10 sections combinedly give you the overall concept of right of private defense. This is the first thing which you should know about right to private defense. Now coming forward, the second thing. Why do we need this concept? Why do we need this concept of right of private defense? So the answer to that question is, students, the concept of self-preservation. Now, what is this self-preservation? You must have heard those muhavras in Hindi that jaan hai to jahan hai. Okay. Sar salamat to pagdi hazar. Now, all these muhavras basically explain the concept of self-preservation. As per to the human instinct, the first thing that comes into our mind is that we need to save our life first, and then you can think about others. So on that basis, at that point of time, when the legal authorities, for example the police, is not available, and someone trying to commit an offense against your body or your property, then you do have the right to private defense for your body as well, and for your property as well, which is based on your self preservation, the concept of self preservation. Very good evening, Ayush. I'm completely fine. I hope you are also doing fine. Okay, I've just started this topic, right to private defense. I've told you as of now just two things. The very first thing, the section numbers 96 to 106, right to private defense has not been defined. Overall, all these 10 sections combinedly gives you the overall concept of right of private defense. And the second thing, why do we need the concept of right to private defense? The answer lies in the concept of self preservation. Now coming forward, when it comes to right to private defense, it should be used as a shield and not as a sword, which means you can save your life or any other person's life. You can save your property or any other person's property. You can use this concept to shield, to defend yourself. But you cannot use this as a sword to attack on someone. Always do remember, students, assailant, the person who is attacking on someone, the term which I'm using, I'm repeating myself, the assailant cannot use the concept of right of private defense. Okay, so you can always use this as a shield and not as a sword, which means this concept only concludes one more thing, and that is that if there are two persons, Mr. A and Mr. B, and if there is a fight between them, can they both claim right to private defense? And the answer is absolutely not. Now, why not? Because right to private defense can be exercised by only one party, either one party or no one. But there cannot be any circumstances where both the parties are using right to private defense against each other. The assailant can never have the concept of right to private defense. The person who is doing the attack on someone, that person cannot take the right of private defense. So which concludes this concept, that the concept of right of private defense can always be used as a shield to protect your own, to defend your own property or body or someone else body or property, but you cannot use it as a sword. This is the third concept which I want to tell you in the introduction itself of the right to private defense. I hope everything is clear till now. If you have any question in your mind, feel free to ask your questions in the comments. Okay, now coming forward, what is section 96? Now I'm done with the introduction part. Now I'm coming to the sections. So the very first section of right to private defense is section number 96. So what is the concept of section 96? So section 96 basically says that nothing is an offense. Nothing is an offense if it is done in your private defense. So let's take a simple example. If there is a person, Mr. A, and he has a sword and he attacked on Mr. B. Now, whatever B did to save his life, if B has done hurt to A or grievous hurt to A, then in that case, nothing is an offense which is done by B in the exercise of his right to private defense. And this concept is confirmed by section 96. Usually students get confused that section 96 defined the concept of private defense, right to private defense, but that is not the correct statement. Okay, the term right to private defense has not been defined anywhere, okay, in IPC. Now coming forward, now what is section number 97? Moving to the next important section. What is section number 97? So I'm just giving you a very simple chart to conclude the overall concept of section 97. So next, section 97 says when we use the word right to private defense, what we are defending basically. So we are defending either the body or the property, or you can say both as well in some cases. Now the question is, whose body we are talking about? Whose property? So the answer to that question, own body and the others as well. Now, who are others in section 97? So, others are basically anyone other than you, which means your family members, your relatives, then even strangers falls under the category of others. Now, similarly, with the concept of property, and here property means movable property as well as immovable property. Now, property, whose property? Own property and others' property. Now I do have one question for you. Can you tell me any difference between self-defense and private defense? What is the difference between self-defense and private defense? The answer lies in section 97. When it comes to self-defense, you are basically talking about your own body only. You are talking about your own property only. But when it comes to right to private defense under section 97, it includes others' body as well, others' property as well. That other may be known to you or unknown to you. That doesn't matter. But this is what section 97 is. Completely correct, Ayush. Own and others, and self-defense is restricted to own. So make sure, usually in layman's language we usually use this word self defense, but when it comes to section 96 to 106, you will never use the word self defense. You will use right to private defense. And right, what is the difference? The difference lies in own body and others, own property and others property. So this is basically your section 97. Now coming to the next part, the next section. What is section 98? So section 98 says, if right now we are doing chapter number 4, which is basically general exceptions. Now the question is, students, what if there is, on one hand, there is a child whose age is of 6 years, and on the other hand there is a person, and this child is having a gun, a real gun, and he is shooting towards this person. Now, if this child, in any circumstances, if this child killed this person, he will get the defense under section 82. But what if this person killed this child in right to private defense, whether that would be considered an offense or not? So he will get the defense under right to private defense. Now, is it possible? Answer is yes. There is a specific section as well on this, and you can refer section 98. So section 98 says, right of private defense against the act of a person of unsound mind or etc. etc. Here means basically if there is a child of below the age of 7 years, so if he will get the defense under section 82. Or suppose if there is an unsound mind person. Now let's take another example. If there is a person, Mr. A, but he is unsound mind and he is doing an attack on some person, so can he, to save his life, to save his own life, can he cause death of unsound mind? The answer is yes. Because if the attack of unsound mind person falls under the category of section 100 firstly or 100 secondly, this person can definitely cause death of this unsound mind to save his life. So section 100 read with section 98 can save this person's life. So this is basically your section 98, what it is. Any questions till now? Very good evening, Anita, Padma, very good evening. I hope you all are doing fine. Moving forward. Now, what is section 99? Next section. What is section 99? So 99 is basically the exception of general exception. Yes, let's take an example. You know, the general rule says if a person commits an offense, he will get the punishment, right? This is a general rule. But if his case fall under any of the general exceptions, the person will not get the punishment. But if person's case fall under section 99, which is exceptions exception, then the person will get the punishment. Now, why the punishment? So basically, can one person use right to private defense against a legal arrest or a legal encounter? The answer is no. You cannot use the right of private defense while doing against a police officer who is doing his own duty. Okay, so let's understand this whole concept with a simple example here. If there is a person, Mr. A, and he is sitting in his home, and then there is a police officer who came in and he's like, you are under arrest. I do have a arrest warrant on the name of you, and that is non-bailable warrant. And A do has all the rights of as an arrested person to know the grounds of an arrest, to see whether the police officer has the arrest warrant or not. And still, if the Mr. A is, start attacking on this police officer on the name of right of private defense, he cannot. Why? Because the police officer is doing his duty, and under section 99, 99 is basically those circumstances when you cannot use the private defense. So in that case, Mr. A, if he has hurt or grievous hurt or murdered the police officer, he will get the punishment. He will not get the defense under right to private defense. So that is your section 99. Now coming to one simple chart that will conclude the rest of the concept of right to private defense. This particular chart is also going to help you understanding what is the relationship between these sections and how you can learn all the section numbers as well. There are three questions which one law student needs to answer in relation to right to private defense. The very first question, when you can cause death in right to private defense. The second question is, when you can cause any harm other than death in right to private defense. And the final, third, one of the most important question, when actually right to private defense commences and when exactly it ends. Now, while explaining this question, why it is important? Because the thing is, students, if your right to private defense commences on this point and it ends on this point, so within this window, you can do whatever you want to. So basically, you do have right to private defense. But before this or after this, you don't have right to private defense. So here you will not get any kind of punishment. But before commencement of right to private defense, if you exercise that, you will get the punishment. After, once it has already ended and you are still exercising your right to private defense, the person will get the punishment. So now coming to where is the answer of all these three questions? Coming to the answer now. Question number 1. When can you cause death in right to private defense? The answer lies in section 100. Read with section 103. If the examiner is asking you when you can cause death, the answer is section 100 and section 103. Now, what is the difference? The difference is section 100 gives you a list when you can cause death when the offense is against your body. And similarly, on this, when it comes to section 103, it is basically on your offense against your property. Now coming to, so this is basically answer number 1. Now, any other harm other than death. So the answer is section 101, which is basically read with section 104. So suppose if someone is committing an offense against your body and that is not fall under any of the list of given under section 100, then you can cause any other harm, okay, other than death under section 101. What is the difference between 101 and 104? Both answer to the same question, any other harm other than death. The only difference is 101 deals with human body, 104 against property. Now coming to the final question, when right to private defense commences and when it ends. So the answer lies in section 102, read with section 105. And now again, what is the major difference? All these sections are when it is offenses against body, and all this list is offenses against property. But now you can understand with the help of this chart that what is the relationship between these two sections. They answered the question number 1. Now anything which you are not clear with from this chart. I hope it's clear now. Okay, Padmala, thank you very much. Okay. Okay, then if it is all clear, then answer my question. I do have one question for you. Listen this carefully, and I want your answer. Suppose there is one person, Mr. A, and there is one person, Mr. B. So A went to Mr. B, and A gave him a tight slap on his face. Okay. A gave a tight slap to B on his face. Now, in that case, what B can do? Can B cause death of Mr. A? Answer in the comments. Can B cause death of Mr. A in right to private defense? Yes or no? And please do write the reasons as well. That why you think so. What are your reasons to defend your answer? Yes, please. Waiting for your answers. Padma Law, first one to answer no. Please state the reasons as well. Why not? Shivendra Yadav, no. Okay, Shivendra Yadav, please state your reasons why you are saying no. Okay, now let me tell you this as well. Why I am so interested in your reasons, because you have gone through with this concept of speaking order, right? There needs to be reasons for every order. Okay, and at the time of your means examination or at the time of your interview, all you need is the reasons to get good marks. Exceeding the right to self defense. No, Ayush, that's not the reasoning. That's not the correct reasoning. Shivendra Yadav, 351. No. No, Shivendra. Wrong. There is no role of section 351 here. Rupali answered. Rupali has written not available private defense because free fight is there. No, partially you are correct, Rupali, but that is not an example of free fight. Okay, now I am giving you the reasoning. First, I am repeating the question, and now after that I'll give you the answer and the reasons. Okay, now listen carefully. My question was very simple, that if A gives a tight slap to B, can B cause A's death on right of private defense? Okay, that was my simple question. Now coming to the answer of this question. The answer is no, B cannot cause his death. Now the question is why not? Why not? Because I just told you when you can cause death in private defense. The answer is either in section 100 or 103. Okay. As per to the facts of this question, section 103 has nothing to do with it. So under section 100, there is a list of 7 pointers. Firstly, secondly, thirdly, fourthly, fifthly, sixthly, seventhly. If you go one by one, you will find that this situation will not fall under any of section 100, starting from firstly till seventhly. So he cannot cause death. So what he can do? All Mr. B can do is he can do any harm other than death. He can do any harm other than death in right to private defense, but he cannot cause death. And if he cause death, Mr. B will get the punishment. Mr. B will get the punishment. I hope it's clear now. Okay, Rupali, so it was not a free fight. Shivendra, it has nothing to do with the concept of assault. The moment one slaps, okay, the moment someone touches another's body, that is no longer an assault. Okay. I hope everyone is clear with this now. Exactly. Ayush, the only thing is, see, okay, let me give you one more formula you can say that how you can reach to the correct answer. The question is, you should know the facts of a case, and after once the facts are clear, you need to see whether death is possible. So as per to firstly, what is the case? Whether death is possible or not. What is as per to secondly? So grievous hurt can be given to that person or not. So if that is not the case, then you cannot cause the death. Okay. But if I change the question, if Mr. A start attacking Mr. B with a sword, so that will easily fall under either firstly or secondly or both. If someone is attacking with a sword, okay, that is a sharp weapon. So in that case, B has all the rights to cause his death to save his life. I hope it's now clear. Now, anything which you are not clear with the concept of right to private defense, you may ask. Done? Okay, Shivendra. So now I have some important announcements to make. Students, this is the link of my profile of Unacademy. This is the link of my Telegram channel where you can connect with me. And if you do have any questions, you can post your questions on my Telegram and I'll personally answer them. Okay. This is my code Khatri10. Let's crack PCSJ with Unacademy. These are the upcoming batches. Regular linking course 2023 recently started from January 26. Rapid revision for Uttarakhand Judiciary. This is started from today only, Feb 1st. Your UK prelims date is also out. Okay. I hope you all are aware with this. And then there is a rapid revision for West Bengal Judiciary, which has already been started from January 23rd. Okay. Your notification of West Bengal Judiciary is also out. You can fill up the forms. So these are the judiciary notes which are available from January 30th. There is a price hike from Feb 1st. If you are preparing for UP or Chhattisgarh, then this announcement is important for you students. If you are already a plus or iconic student, you can attempt these tests completely free of cost. But if you are a special class student, then only again a very minimum price, that is 500 only. And again, you can use the code and get 20% off as well. Okay. There are 3 full length mock test is available for you. That is on 3rd Feb, 5th Feb and 7th Feb. Similarly, for Chhattisgarh Judiciary, there are 5 full-length mock test is available. These are the dates of the basically your test schedule: 6th Feb, 9th Feb, 12th Feb, 15th Feb, and 18th Feb. I guess the test of the prelims examination of Chhattisgarh Judiciary is on 26th, if I'm not wrong. So that's it from my end, students. So see you in my next class. Till then, yes, it's time to say peace.